Hey everyone, welcome to Wealth Redefined. I'm your host, Michael Reynolds, independent financial advisor and owner of Elevation Financial. Thanks for joining me today. Happy to have a co-host / guest with me today. I'm glad to welcome Jeff Heinzmann with Heinzmann Law Office today. Jeff, welcome.
Thanks, Michael. Happy to be here.
Glad you're here. Good to see you. So we are going to talk today about basic estate documents, including a last will and testament. And I know it sounds strange to say I'm really excited about this because I can't imagine people get super excited about estate documents, but I think it's a really great conversation to have for a number of reasons. So I'm looking forward to it. So Jeff, you and I have known each other for a while. I've worked with you in different contexts for a while. You've helped me with a lot of contract counsel and legal counsel on various topics, and really enjoyed working with you. So I'm happy to have you in this conversation today. So you are the owner of Heinzmann Law Office, located in Fishers, Indiana, which is just down the road from where I am. You're based in Indiana. You do one of your taglines is "I do other stuff," which I love because you have a specialty in estate planning, but also in business contracts and lots of other areas. So I really appreciate how flexible and well-rounded you are when you help people. So let's start things off with a little bit about you. Let's hear a little bit about your background, your professional life, kind of how you got here, and a little bit about you, Jeff.
Sure, Michael. Yeah, you hit that right. I am a general practice street lawyer, as a friend of mine calls it. I do a little bit of everything. I love to help people get their estate planning documents in place. Happy to review contracts for people because we know that is something best done in advance. I always explain that to people. It's the client who doesn't want to take a little time and effort and invest a little in reviewing a contract before they sign it winds up investing a lot of money fighting over what it means later. But I am a Hoosier by choice. My wife and I located here. I went to law school down in Bloomington. My wife went to Purdue, and we met in the Indianapolis area the summer that I was studying for the bar. I did my undergrad up at Northwestern University and spent 8 years with a couple of small firms doing nothing but civil litigation, trying cases mostly on behalf of businesses, but a little bit of personal injury, a little bit of other stuff. And then I spent 11 years with the state as deputy state auditor and counsel there. And then I ran the statewide small business development program for Governor Daniels for 5 years at the Economic Development Corporation. After that, I was in-house with a small IT staffing consulting firm. And then in 2015, I hung out my shingle and opened Heinzmann Law Office. I'm a solo practitioner. I love being my own boss and just having me and my clients to work with. It's wonderful. I've done everything from litigation and appellate work to very minor criminal stuff to general business litigation, business formation, contract review, and as I think we're going to talk about, some wills and estate planning as well. So I do some zoning work. I had an impeachment trial for a public official. I do some election law work too. So like I say, I do other stuff. I a little bit of everything, and it keeps life interesting. So
yeah, I'll bet. And then one thing I've noticed also is you're really good about if by chance there's something that doesn't fall within your realm of expertise, you have partners and a network you can reach out to and refer as well. So you're a great resource for all things legal, in my opinion, whether it's something you could handle or someone in your network can handle. So I really appreciate that.
Yeah, thanks. Yeah, I've been a lawyer for 28 years, and having been with firms and with the state and literally all over the state, I do have friends and contacts at firms all over in all sorts of more specialized niche practices where I'm able to, one, tap them for information if it's something that I can help with, but need a little more information on. And two, I can refer things back out to them. And it's very much been a two-way street for me with my friends on that. And it's a great way for me to leverage my contacts to make my practice better and to help my clients.
Right. All right. So let's talk estate planning today. So obviously, and my listeners know, I do financial planning with the individuals and families that I serve. And one of the things that comes up in pretty much every financial plan is a discussion around estate planning. And I've noticed that it's very common for people that I work with to not have a will in place or a basic set of estate documents in place. And that's one of the things that we touch on early on is, hey, here's a checklist of things that are really important to consider getting in place, along with things like insurance and investment accounts and the usual stuff you might expect. But, the will and the estate documents is a piece that is often missing. And I really feel it's important to bring that up during the financial planning process. And of course, I love working with you, and we share some mutual clients. And so, being able to leverage your expertise today, I think is really important, because often people don't understand the importance of this basic level of estate documents. They think, oh, well, a will is for when I'm old and, setting up my estate for leaving behind to my kids and grandkids. And they think of it as some far off thing, right? They think of it as, hey, the will is this far off thing for when I'm, 89, 90 years old. And, that's when I think about it. But that's not really true. There are many, many good reasons to establish your basic estate documents as early as possible. And I'd love to walk through those things. So,
yeah.
Jeff,
yeah. No, go ahead.
Yeah. So I know that you have a really nice, obviously you do estate planning in many contexts. I'm sure there are some very complex cases you work with, but often I'm just going to say kind of regular people with kind of regular needs, nothing terribly complex. You have a really nice set of kind of a package of estate documents that you kind of productized for your clients that can come to you and say, hey, we have pretty straightforward needs. We need this estate document set of stuff put together. And in that package, you have a set of documents, including a last will and testament, a living will, power of attorney, healthcare representative appointment, and transfer on death deed. And I want to unpack those things and talk about what they mean so people understand the importance of these things. So if it's okay with you, let's start with the will, kind of the most commonly recognized piece of it.
Well, when you have a will, basically you're putting in writing and committing to, this is where I want my estate to go if I pass away. And a lot of people say, well, it's just me and my wife, and so we don't have any kids, we don't have anything else. There's no need for me to have that. But if you pass without a will, then you pass under what the law calls intestacy. You die intestate or without a will. And when that happens, if you're survived by children, as well as your spouse only gets half of your estate. The other half goes to your children. So, typically in a will, we're just going to have it go straight from spouse to spouse and do it that way so that spouse who's got to take care of the children has access to everything instead of having half of it winding up in a trust for these underage children.
Now, is this a state-specific thing that happens, or is this pretty universal?
This is, I don't know exactly what the intestacy laws are in other states, but every state has intestacy law. And so this is Indiana's law on that. And that's a great question. Generally, it's going to be something similar to this. In Indiana, if you die with a surviving spouse but no kids, your spouse gets 3/4 of the estate if you are survived by one or more of your parents. So, you get married, you don't have kids yet, you don't put a will together, and you die, 1/4 of your estate goes to your parents, and your wife or your husband who survives you only gets 3/4 of your estate. So there's a good reason to go ahead and prepare this just from a basic issue there. Now, the estate tax, the federal estate tax threshold, I believe next year is going to be over $12 million. So we're not really doing wills for estate tax purposes anymore. In Indiana, there is no estate tax at the state level. So that's the only question is how big is your estate there? What I try and do with my clients is have them take steps when they enter into a will to minimize their estate. That means taking advantage of things like transfer on death deeds for your automobiles. So if you don't own your automobile jointly with somebody, figure out who you want your car to go to. You go to the BMV and you do a transfer on death title, and you name someone who's going to get that. Then that car, which may be an asset that has some value, is only going to pass directly to them and not go through the estate. What this does, you do that with bank accounts too. Make sure you have your beneficiaries in place for your accounts that you have invested with Michael. And when you do those things, all those things pass outside the estate. They just go directly by operation of law under those contracts. This keeps your estate smaller so that it doesn't rise to the level where it has to be probated, which means you have to file and go into court and have a court somewhat oversee the distribution of the estate. You can just do a small estate affidavit and be done with it, and let things move the way you wanted them to. It doesn't clog things up. It keeps the costs low, and that's just a great way to be able to handle things. The other thing that I do is with homes. I encourage people to do what's called a transfer on death deed. So you record a deed with the recorder's office that says, my wife and I own this house as tenants by the entireties, but when the survivor of us dies, or when we both die, when we both pass away, we want this house to go to somebody else. And usually it's the kids. But again, if it's not kids, you can set it up so that it will transfer upon your death when somebody files when the person who's the beneficiary under that deed files a survivor's affidavit with the recorder's office and gets that recorded of record. Then the title to the property passes to them, and you didn't, again, have to go into court, probating a will, having this pass through those steps. Doing these things makes everybody's life a lot easier, helps things be planned out in advance. If you do a transfer on death deed to it, in no way limits your ability to do anything you want with that property. That is a contingent beneficiary, contingent upon you passing away. You can sell the property and that contingent beneficiary's interest totally disappears. You can still mortgage the property. You can still lease it. You can transfer it to somebody else. So there's absolutely no benefit to that beneficiary unless and until the owners have passed away. And again, those are just really nice, simple things to do. The other benefit of preparing your will, if you do have children, is you throw in there provisions for who's going to take care of my kids if I pass away. A lot of young parents, maybe the grandparents are young enough that that's who they want their kids to go to. Well, you can set that directive up. But as time goes on and grandparents get older and maybe less able to keep up with or take on this, maybe there's a sibling. Maybe you don't have siblings that you or your spouse don't have siblings you'd like to leave your kids with if that happens. And it really is actually a friend or a neighbor. And you have that conversation and say, if God forbid something happens to us, will you take on our children? We have this much in life insurance. There'll be funds there to help take care of them, but we really like you, trust you, the kids know you, etc. So you get that into the will as well. And what we do in the will also is we create a testamentary trust in the event children or anyone taking under the will has reached a certain age. A trust would be created. Trustee is named in the will, and if not named, it can be appointed by someone later through the personal representative of the estate, so that until those beneficiaries reach a certain age, that interest can be monitored, used for the health, education, support, etc., of the underage child, or not even necessarily underage. We do this with a lot of people where people don't get their parent, if the children don't receive the benefits of the parent's estate until they're 25 or 30 or 35, because sometimes the idea of giving the entire estate to an 18-year-old kid might not be a good idea. So that doesn't mean they can't benefit from it. Again, the trustee will be providing for their education, for their support, if there's an emergency, if there's something they really need it for. And you can spell that out in the trust and in the will as to how you'd like that to happen. But there's a good number of reasons you'd want to do that. So that's the will, basically, and those are the basic reasons why you'd want to do that.
Yeah, I think a lot of people don't even realize at the basic level that, like you mentioned, half your estate goes to, your spouse, and then the kids, and then maybe a quarter goes to your parents. Like, they don't realize those rules are already set up in place, and how a will is great to be able to supersede those things if that's not what you want to happen. And it sounds like
Right.
if you don't have a will in place and you pass, the state just kind of takes over, which can make a mess of things, right? Is that fair to say?
Well, I mean, in fairness to intestacy, it sets up rules that are there if there's nothing that's been said.
Right.
So this is the fallback. This is the safety net. And the safety net is that, the wife gets half and the kids get half, or the wife gets half. I keep saying wife as if it's only the husband who's passed
House, yeah.
away. The surviving spouse, gets 3/4, and the surviving parents of the deceased spouse get the other quarter. And some of that probably dates back to when people were more in tune with being the ones who support their parents in their old age. But that's sort of probably the history of that. But that's what happens if you don't have a will. And so, we'll set up wills where we've got beneficiaries and contingent beneficiaries if people don't survive, and you can keep going down that line. And at the end of the day, if there's nobody else at the end of intestacy to take the money, it does wind up going to the state. So if you don't want that, then what you want to do is have a will that says, and if, here's my beneficiaries, and if they don't survive me, I want it to go to this charity, to this cause that I care about, or to this church, or to this, humane society, or whatever it is that somebody might want their estate to go to in the event that they pass away. If they don't put that in place, and all the other dominoes fall so that there's nobody there to take it under intestacy, it will go to the state.
All right, right off the bat, really good reasons to consider a will at any stage in life. So let's talk about the living will.
Well, the living will is part of advanced directives. The living will form in Indiana is very basic, and there have been some changes in this, and I'll get to those in a bit. But the living will basically says, if I get put into a position where extraordinary means are going to be necessary for me to be able to survive, I don't want to be put on a machine for a long period of time. I don't want to be kept alive if there's no hope for my recovery by receiving, intravenous nourishment and just be, someone who's taking up a bed. This is a very personal, very difficult decision for people to make, but it's one of those things that needs to be dealt with. And in the Indiana living will form, there's basically 3 boxes to check. I wish to receive artificially supplied nutrition and hydration, even if the effort to sustain life is futile or excessively burdensome to me. I do not wish to receive artificially supplied nutrition and hydration if the effort to sustain life is futile or excessively burdensome to me. Or I intentionally make no decision and leave this decision to my healthcare representative who I've appointed. It's important to do this in advance so that people know what you want, so that hospitals know what to do, so that your family knows what you wanted in the first place. This is, just one piece of advanced directives. That third blank that I mentioned, leaving the decision to my healthcare representative, is another document we do called a healthcare representative appointment form. And under that form, you say, if I can't provide direction to my medical providers, if I'm in an accident, if I'm in a coma, if I somehow lose the capacity to make decisions, I'm picking in advance this person, usually a spouse, sometimes a parent, sometimes an adult child, to make the decisions on my medical care. And you need to have this in place. And I've seen situations too. I frequently recommend that people come up with an alternative, because sometimes when someone is in that situation, they've named their spouse to be the person who makes the decision, and the spouse is not handling the situation well and is not able to continue really making those decisions well. And it's too much stress for them under that situation. And so that's a thing. It's important when you're making the choice to do this to first and foremost have that conversation with the person you want to be your healthcare representative. Make sure that they know what's going on. Make sure that they understand you could be called upon to make some difficult decisions. Um, and also to set up a backstop and say, if that person is unwilling or unable to do this, then in lieu of that, I appoint this other person, so that people know. And generally, a family is still going to get together, a spouse and adult or near adult children or parents. They're going to get together and they're going to talk things through when those situations are going on. But it's important, to have that considered up front. And that way, when you execute those documents, it's a good idea to get them to your doctor, have them put in your doctor's file, so that if this happens, you don't have to scramble to find it at home. You know it's in a medical record someplace.
Yeah, this is the document that I find is most convincing to people, even if they don't necessarily feel like a will makes sense for them, because again, they're still thinking of it as this, far off thing. When I bring up the living will and how important it is to provide that gift to your loved ones of decide in advance on what your wishes are, because you never know when something's going to happen. You never know when we're going to have an accident or some, hopefully, doesn't happen, but it
Right.
does happen to some. And, if we're in some sort of situation where we're incapacitated medically, what a gift it is to be able to have those guidelines set up so the people that are caring for you know what you want without having to agonize over the decision more than they have to. So I think that's one of the things that's most convincing to people universally is that living will. It's
Yeah,
very
I think, yeah, the living will and the healthcare representative,
yeah.
those plus the general durable power of attorney are things that you want to get put in place, because you slip and fall and hit your head, and the next thing you're not able to take care of things for a period of time, if or worse. And that's the other thing. The living will is more for the end of life situation, the ability to sustain life being unduly burdensome, and how would you want that handled. It's nice to take that question off of somebody's plate, but the healthcare representative and the power of attorney um, enable someone to help take care of you, to help make decisions, because you need to be kept in an induced coma for a period of time. But somebody's got to make the decisions on certain medical care questions as that goes along. Meanwhile, out in the rest of the world, your car payments still due, your property taxes are still due, everything else is going on, and somebody needs to have the authority to do those things for you. And that's what the general durable power of attorney takes care of as well. So you attach these things together. And I mentioned there's been some changes. Indiana passed a new law this year that is streamlining those three documents into one advanced directive. The ones that we use now are still good through the end of 2022, but lawyers like me are looking at the new statute and coming up with a new version of the form that'll make that a more simple document. It'll still need to be signed by the individual, either in front of a notary or in the presence of two witnesses, but it's going to, by the end of next year, replace the traditional three documents with one advanced directive form.
Okay. So I love that we were able to walk through all these different components and kind of unpack what they do. And you brought up a good segue that I was going to go to next, which is the logistics of handling these estate documents. So it sounds like, from what you said, to make them legal and valid, you have to sign them and then sign them in the presence of a notary or two witnesses. Is that correct, based
Yeah,
on the state of Indiana?
yeah, it depends on the document. If we're going to talk about the will doesn't have to be notarized, but it needs to be signed in the presence of two witnesses, and it has a very specific, for me, it's a separate page, clause called a self-proving clause. And what this does is it basically helps prevent people from being able to challenge the will unless they can come in and show some sort of undue influence that was brought to bear on the testator when they signed. Those two witnesses will sign along with the testator. The testator is you, if it's your will. And you guys will initial every page. And by using the specific language that's required in the self-proving clause, then the will itself will be accepted if it needs to be probated by a court as a accurate and valid representation of that testator's will. So the other documents, historically, I've had my power of attorney has always had a notary block on it. But as I said, the new statute for the combined advance directive form says that you can either get it notarized or you can have it signed in the presence of two witnesses. So you're going to be using two witnesses at the time you do your will anyway. You might as well just do the two witness form and have those two people be the witnesses on that as well. Sit down, sign it in front of them. There's also going to be options for virtual signing, which is something that's been done. I've not dove into that very deeply. I still like to be able to, I really like to sit down and go over these documents with my clients so that they feel comfortable with what they've got and understand where they're going with them.
So is having a document notarized a good substitute, or are there some documents where you just literally have to have two witnesses?
The self-proving clause on the will requires the two witnesses.
Okay.
So a will is not something we don't just, you can add a notary on there, but you're still going to want the self-proving clause to have the will done here in Indiana.
Okay. Just to make sure it never gets challenged. Okay.
Yeah.
All right. Makes sense. Yeah. So kind of an add-on question to that related to logistics. How do you recommend people store their will? Do you recommend they keep it in a lockbox at home? You mentioned also keep it on file with medical professionals, electronically or virtually in the cloud, with an attorney. What do you recommend?
I recommend that people keep the original someplace safe, a safe deposit box at a financial institution, or if they have a safe at home, and that they let their lawyer know, or they can also keep it with their lawyer if they want. If they want to keep the original there. I usually do an original and a copy, and I'll keep one, and I'll make sure my clients have one. You can keep them virtually, but it's always good to have the original somewhere. It's just, someday you might wind up with a judge who's in a situation where they really insist on seeing that original. And if that's the case, it's best to have that. Otherwise, the best evidence rule can take precedence, and you have, but you start, all of a sudden you start needing to have people testifying, yes, this is what it was. It's just an extra step in the process. So always good to have the original around someplace and to know where it is. But yes, I always recommend if you've picked someone who's your executor, who's going to be the person who's going to oversee or be the personal representative over the will, that they're aware of that and they have a copy. You can share it with your whole family if you like. If you just want to share it with them, that's fine. I recommend on the advance directive getting a copy to your doctor or doctors and to the people you choose as your healthcare representative, so that they know, and so that if something happens, they have a copy someplace and they can come forward and say, yeah, this is my brother, he gave me this, I'm his healthcare representative, here we go. And we talk about what needs to be done then. And that way, you've got those things where they need to be.
Okay. And then let's say, I know you recommend often updating your will periodically, especially when life circumstances change. So when you create a new will, does it automatically just take precedence over the previous one?
Well, you always put, if you do a brand new will, and it's a whole change of the will, you just say, here I am, I'm Michael Reynolds, I'm of sound mind and body, and I, declare this to be my last will and testament. You put in a line revoking all prior, last wills and testament execute. And, if you can specifically say, specifically revoking the last will and testament executed on such and such a date, you can really identify it. Just saying, pulling that one back. Frequently what you're doing, and it's, since we do these as forms, it's not that hard to just do a whole brand new will. But sometimes you can just do what's called a codicil, which is a fancy term for an amendment to the will. So let's say the reason is, I have 3 kids now instead of 2. And so we're going to change that. So you can just do a codicil that changes the provision of the will, that identifies what, inheritance going to the kids and in what shares, and you can do it that way. You'll put a self-proving clause on the codicil and sign it the same way you would a will,
Okay.
to make it valid like that. But it's a pretty easy way to do it either way. I think, does that answer your question? I thought, was there another point?
Yeah, that does answer my question. Thank you. So I'm going to put you on the spot a little bit. You can decline if you want to make it more customized. But as far as pricing, it's not that expensive. I've been very impressed with how streamlined and how inexpensive your particular will package is. So, as a general rule, what is even a broad range of what someone might expect to pay for an attorney to work with them on a package like this? Basic state documents.
I don't know in other jurisdictions in other states. What I am currently charging for a simple wills package, no transfer on death deed, just a married couple, the two wills, and then the two sets of advance directive documents, charging $825 to do that. So generally keeping that under $1,000, I've found is sort of the price point where people find that to be pretty reasonable here. If you get into, I don't want it to be just plain like that. I want to do some sort of revocable trust, and I want to throw on transfer on death deed. I do recommend the transfer on death deed for people. It's just, again, you want to avoid probate in Indiana. You want to keep your estate under $50,000. So when you have equity in a home, you typically want that to be put into a transfer on death deed, takes the house out of your estate. Again, you do the same thing. That's the statutory limit, unless it got changed this year, which I probably need to check.
What does that mean? How is that?
That means if your estate is larger than, if your estate reaches a certain limit, then you have to probate your will. You have to take it into court, and the court will kind of oversee the process for you. That's what probating, and that adds costs. That adds an attorney taking it, going to court
and making time, I assume.
And right. And so what we try and do again is minimize your estate. That's why we say make your bank accounts payable on death. Do a transfer on death deed for your house. Do transfer on death title for your cars. Make sure you have all your beneficiaries in place for your retirement accounts. So all of these things, which make up the bulk of your assets, wind up going to people in that way. You can also do this with interests in a company. Interests in an LLC can be transferable on death to people. You can own parts of an LLC as joint tenants with right of survivorship with people, so that you can again avoid having death be as difficult. As difficult as it is, you can make it worse by not having these things in place in advance.
A lot of good stuff to think about. I like how that's what you mean by keeping as much out of the estate as possible. And that's, it seems like it's a very, I don't want to say simple because it's a lot of stuff to think through, but these tools are available and a lot of us don't realize that. So I'm glad you shed some light on, especially the transfer on death deed. Those are really useful tools to keep things out of the estate for that reason.
Yeah.
So, this is awesome. Thanks for sharing, Jeff. This has really been
my pleasure. It's good to be here.
Yeah, it's been a great eye-opening conversation about these documents. Is there anything I haven't asked that you think is important for our listeners to know?
No, I think we've pretty much covered what we needed to cover here today. I'm always happy to talk to people about this and help them out. It's one of those situations where, people know they need to do it, but they don't want to. And we're talking now. It's the Tuesday before Thanksgiving. It's a great opportunity for people when they're going to get together with family to maybe think some of this stuff through. It's not necessarily the happiest topic to have around the Thanksgiving table, but it's a great opportunity as you enter into this season, and especially making sure that the elderly people in your family have the documents in place. If they haven't had them looked at in a long time, maybe it's time. I hate to say it, but my father slipped and fell on ice several times late in his life, and one of his slip and falls wound up being his last one. you want to make sure you've got that stuff in place, because the day after that's happened, it's too late to get it in place and to figure out how you're going to get through the coming challenges that you face. So
thank you. Well, let's on that note, let's talk about where to find you. So I know you practice law in Indiana. So if someone is located in Indiana, obviously they can reach out to you for help. If they're outside, I'm sure they can still maybe ask for a referral. I'm sure you know people in different states. But what's the best way for someone to reach you, Jeff?
Sure. I have a Facebook page at Heinzmann Law Office, which is operating out of Launch Fishers, which is a co-working space here in Fishers, Indiana. It's a wonderful northeast suburb of Indianapolis, where we've been for 20 some years already, my wife and I. You can reach me by telephone at 317-696-6031, or you can reach me at jeff@heinzmannlaw.com, and you can see my name on the bottom of the screen there. That's heinzmannlaw.com. I would be happy to take an email or talk to anybody. The way I do the estate planning process with most people, if it's the simple package, is we sit down, we make sure there's no conflict and no reason why I couldn't represent the person. And then I send out a little questionnaire, which gets me the information I need to prepare drafts of the documents. Then we'll sit down and go over them. And generally they're pretty much what people need right up front. But if there are tweaks or changes that need to be made or questions that need to be answered, we take care of that and move the process along.
Awesome. Well, thank you, Jeff. And if anybody wants to get in touch with Jeff and forgets that, just email me directly, podcast@elevationfinancial.com, and I'll make sure you get in touch with Jeff. So Jeff, thank you so much. Great conversation today. Super useful. Really appreciate your time.
My pleasure. Thank you, Michael.
All right, everyone. Thanks for joining us today. As always, appreciate you being a listener. You can find me on the web at elevationfinancial.com. And if you'd like to book a time with me to talk about anything at all, use that big friendly button on the homepage, and we'll do a complimentary money session and chat about whatever you want. All right. Thanks, everyone. Have a great day. See you next time.